That was, Your Honor, that was my fault. I had two defendants with the same exact Samsung name. And so when I asked in the waiting room who the defendants were and to give me their first and last names, the Samsung responded and said it was Jose Ramirez. So I have Jose Ramirez in the waiting room still, but Brock Collins hadn't given me his name yet. I just had two with the same name.
I see. All right. Well, maybe I ought to get the other one in here and let Mr. Collins wait a while, but it looks like he's only half with me, so maybe
No, I'm here. I'm here with you. I've just been waiting patiently.
All right. Well, let's see. We are on the record.
This courtroom moment starts off chaotic, but quickly turns into something much bigger. A simple identity mix-up, a defendant trying to fix decades-old mistakes, and a legal system that demands more than just good intentions. Stay with us, because this case takes a sharp turn from confusion to confrontation, and a surprising ending you won't expect.
Jose Ramirez. So I have Jose Ramirez in the waiting room still, but Brock Collins hadn't given me his name yet. I just had two with the same name.
I see. All right. Well, maybe I ought to get the other one in here and let Mr. Collins wait a while, but it looks like he's only half with me, so maybe
I'm here. I'm here with you. I've just been waiting patiently.
All right. Well, let's see. We are on the record in 2002, 24-3024, State of Kansas versus Brock E. Collins, Jared Regier for the state, defendant in person and pro se. Mr. Collins, you've filed a motion in this case on your own behalf. And let's see, you originally were charged back in September of 2002, speeding 93 and a 70 and driving without insurance. And then, I don't know what happened after that, if you paid the tickets.
Right off the bat, there's confusion about identity, and that's not a small issue in court. Every charge, every motion, everything depends on the correct person being identified. If the court gets this wrong, the entire case can fall apart. Imagine being in this situation. Would you trust the process?
But then May 14th of this year, it says you called and wanted the court to find through a hardship program that I should go back and, well, you just tell me, go back and what, waive your fees?
Well, what I'm trying to do now, ever since then, my license has been revoked, and they just came up for reinstatement. The revocation has been uplifted June the 6th of this year. And in order for me to get my license back, I'm trying to get all these outstanding fines that I had. I'm trying to get them all taken care of. And so far, I've done that. And you happen to be the last one that I want to get taken care of in order to get my license back.
All right. So, and I do see you have suspension fees of $586. Well, that I think includes your fines and costs, plus your reinstatement fees, $586.
You say the suspension. You say suspension fees or reinstatement fees?
Reinstatement. They're reinstatement fees added on to the fines and costs that you didn't pay. Mr. Regier, what is the state's position on this? Have you seen a copy of his motion?
Your Honor, with all due respect, the state did file a response to this motion.
Yes.
Now we're dealing with charges from over 20 years ago.
Your Honor, the state is prepared to proceed in this matter if indeed the court is
go missing,
prepared
and proving
to proceed in this
anything
matter.
becomes harder.
Well,
the defendant wants
relief,
but the law doesn't just forget because time passed.
Go ahead.
Should old
Mr.
mistakes
Collins,
still
do you have
carry
any
this much
evidence
weight
you want
today?
to present today to support your, and I started to read that earlier and I got sidetracked by something or someone. Would you summarize your response, Mr. Regier?
Yes, Your Honor. The state's first position is that this motion is not properly before the court under KSA 60205A1D. Pursuant to the same, except as otherwise provided in this chapter, each of the following papers must be served on every party. A written motion, except one that may be heard ex parte. The state specifically notes in its response, although the state acknowledges that the defendant's motion does include boilerplate language for a certificate of service, such boilerplate language includes neither a purported date of service nor any purported recipients of the motion, nor does the motion include any attached documentation in support of any attempts by the defendant at serving the motion on the Butler County Attorney's Office as required by statute. So the state's first position is that this motion is not properly before this court. The court finds that the motion in the alternative is properly before this court. The state acknowledges that pursuant to KSA E1 and E2, a person who is assessed a reinstatement fee or a fine or cost for a traffic citation may petition the court at any time to waive payment or fine or costs or any portion thereof. However, the state respectfully submits that the defendant is not entitled to seek relief under either of these subsections. In the defendant's motion, the defendant has failed to make a showing that this court has in fact assessed a reinstatement fee pursuant to KSA 82110 subsection C or any additional charges pursuant to KSA 82110 subsection F in this case. Likewise, the state respectfully submits that the defendant is not entitled to seek relief under KSA 82110E2. That statute specifically provides that a person who is assessed a fine or court cost for a traffic citation may petition the court that assessed the fine.
The prosecution is getting very technical here. They're saying the motion itself might not even be valid. Missing documents, no proof of service, no financial records, these are serious legal gaps. In court, you don't just tell your story, you have to prove it.
Or costs at any time to waive payment of the fine or costs or any portion thereof. The plain language and use of the past tense in this subsection, the state respectfully suggests a procedure for seeking post-conviction relief, and the state is not aware of any journal entries of conviction or sentencing on file with the court in this matter. However, if the court finds that the defendant is entitled to seek relief under either of these sections, the state respectfully submits that the defendant has failed to meet his required burden of proof. Regardless of whether relief is sought under either of these sections, both subsections specifically mandate that the defendant seeking relief must make a showing to the satisfaction of the court that payment of the amount due will impose manifest hardship on the person or the person's immediate family. In paragraph 1 of the defendant's motion, the defendant alleges 9 separate financial obligations in varying amount. However, the defendant has failed to attach to the motion any bills, ledgers, proofs of payment, or other documentation confirming the alleged amounts. Additionally, in paragraph 1 of the defendant's motion, the defendant alleges a new source of income over 2 months before the defendant's motion was filed with the court, but fails to allege any amounts received from such source of income. In paragraph 2 of the motion, the defendant alleges the existence of an attached poverty affidavit, but the defendant notably failed to attach any such poverty affidavit to the motion, nor is the state aware of any separate poverty affidavits on file with the court as of the date that the state filed its response, nor is the defendant's motion notarized. Under these circumstances, the state respectfully submits that first, the motion is not properly before the court. The defendant is not entitled to seek relief under any of these subsections, and if the court finds that both of those are in fact proper, that the defendant has failed to meet his required burden of showing how paying any amounts owed in the current case will impose a manifest hardship on him or his immediate family, and for those reasons, the state does move the court to
This is
deny
where
the
things
defendant.
get emotional. The defendant admits his past mistakes and shows he's trying to change. But courts don't run on feelings, they run on evidence. Even if he's being honest, without proof, the judge can't legally help him.
Its motion in its entirety.
Mr. Collins, anything else you want to say?
According to this hardship piece of paper form that I filled out, everything that this young man is speaking of, it wasn't noted in there. So as far as all these extra attachments and whatnot, first of all, I don't have to lie about my job. I don't have to lie about any of my financial responsibilities. And I'm trying to make an effort to try to get all this stuff done. So in regards to what he's saying, I mean, if the courts grant that, fine, but if not, that's fine too, because I'm just trying to do what I got to do to get everything legal and become I'm a law-abiding citizen. I've made mistakes, I've fixed them, and I'm trying to correct this one as well. So, in addition to Sedgwick County, the city of Wichita, Derby, I've gotten all that stuff situated. And you are the last person that I'm having an issue with. And I didn't have none of these issues and I filled out the same type of hardship form to get my fines and my tickets done, and everybody else agreed to it. So I don't understand why this young man is making such a big fuss about presenting this, presenting that, when I just followed the lines of the affidavit.
So you've had convictions in at least 3 other jurisdictions, and you filed the motion to late, like you did in this case, to go back and set aside the fees and fines, and they all just kind of rolled over on it, as the saying goes.
Yes, ma'am. I mean, I don't have to lie. You can check it. You can check into it yourself.
Okay. Well, all right.
And then I called the Department of Revenue in Topeka.
Now,
and
he
spoke
says
to-
other courts already helped him in similar situations. But every court is different. Just because one judge allowed it doesn't mean another will. That inconsistency can feel unfair, but it's how the system works.
her, and I just sent in a $400 payment to pay my fine there and my restitution there with them. So I have made the effort to get all this done. Like I said, it's been over 20 years since I've had a license, and now I'm in a position to get them back. And so now I'm doing everything that needs to be done and get these certain fines taken care of that she told me that I needed to get taken care of in order to make sure that that happens. And November the 18th, I will get my license back.
Mr. Regier, one thing that I would ask you is your opinion on whether or not the statute he's relying on is retroactive or not.
Your Honor, I am currently in the process of researching that matter, but so I'm not in a position to advise the court fully on that issue at this time. It is the states are saying that this court has addressed that issue in the past, and I am in the process of researching that issue. As to the only thing I would add further is it would appear that the defendant has admitted on the record today that he has the financial wherewithal to send $400 to a necessary state agency. So again, the state would respectfully submit that further calls into question the appropriateness of the motion, if indeed the court again finds that this motion is before the court, and 2, that the defendant is entitled to seek relief under 1 or 2 of these requested subsections.
Mr. Collins, where have you been? Why have you not paid this before now?
Well, I've been incarcerated.
Okay.
I've been in the hospital. I almost bled to death. I had a bleeding ulcer. So I've been dealing with a lot of other issues, personal issues, other than the fact, like I said, legal obligations that I've been incarcerated. So having a bad attitude. I mean, like I said, I've grown up a lot, but at one point, I had a different.
This is a key moment. The prosecution points out he paid $400 somewhere else. That weakens his hardship claim. If you can pay one place, the court assumes you might be able to pay here too. That's a big problem for his case.
Position that wasn't quite what one would be considered normal. I had a real bad attitude, so it kept me in trouble a lot. So being in and out of the penal institution, that prevented a lot of things from happening. And then along with other stuff. So, but like I said, I'm in a position now. I'm in a better position, a better headspace, and I'm trying to move forward instead of continuing to go backwards. And that's all I'm asking. I'm just asking for assistance to get this done.
Well, Mr. Regier, I'm not sure the timing on these things matters, but you did get the motion and you got it in time to prepare a written response. But you're objecting to what part of the procedure?
As a preliminary matter, the state is objecting to the to whether or not this motion is properly before the court in the first place for the reasons stated in the response.
And for the hearing record, that reason is?
Your Honor, pursuant to paragraph 3 of the state's response, KSA 60205A1D provides that, quote, except as otherwise provided in this chapter, each of the following papers must be served on every party, a written motion, except one that may be heard ex parte. And although the state acknowledges that the defendant's motion does include boilerplate language for a certificate of service, such boilerplate language includes neither a purported date of service nor any purported recipients of the motion, nor does the motion include any attached documentation in support of any attempts by the defendant at serving the motion in the Butler County Attorney's Office as required by statute.
But again, I go back to some.
And just like that, the judge denies the request, not because he didn't try, but because he didn't meet legal requirements. No evidence, no proper procedure, no relief. That's how strict the system can be.
Now you got the motion. How did you get the motion to prepare a response if it was never served on you? Did you go down and get that because you heard a rumor that it was on there? Or how did you even know it was on file if he didn't notice you for it?
Your Honor, my office received notification that this matter was set for hearing for an unknown reason, and for that purpose, I accessed the electronic file.
All right. What I'm inclined to do is give you more time if you want that, Mr. Regier. Set this over and we'll hear the further arguments and any evidence at a later date. Or do you want me to proceed at this time with what we have?
Your Honor, the state is prepared to proceed in this matter if indeed the court is prepared to proceed in this matter.
Well, I've got a lot of folks, as you know, here, but let's go ahead. Mr. Collins, do you have any evidence you want to present today to support your request?
No, ma'am, other than what I've just told you. I mean, like I said, I've made a lot of mistakes in life, and I'm trying to correct them. Like I said, I've just got out of court with Sedgwick County, the city of Wichita, both Park City and Derby. And like I said, I'm just trying to clean up my record, and I'm trying to get my license back. I have an opportunity to be a CDL driver, and I'm just trying to move forward. So with everything that's going on right now, you know, opportunities, I've had a lot, I've messed up a lot, and I'm just trying to correct them as I go.
Okay,
And all I do, oh, excuse me, go ahead.
do you have any evidence, anyone you want to call, any documents you want to show?
Are you talking to me, or are you talking to the
Talking
district?
to you, Mr. Collins. I started to go to Mr. Regier, then I decided I'd go back to you for a few more things.
Well, the only thing that I really have is like, I have a letter from the Department of Revenue letting me know when my license are due to be returned to me once I get all my information done. I just got that letter. Like I said, I don't really have a whole lot to show. I could show check stubs, but I wouldn't prepare because I'm not at my house right now. I'm at my friend's house doing this. She helped me with the Zoom situation to make sure that I came to court on time. But I do have.
In the end, this case shows how the legal system works. Effort alone isn't enough. You need proof, process, and proper filings. Even though the defendant tried to fix his past, the court had to follow the law. Interestingly, the case later got dismissed, bringing a surprising twist. If you found this case as shocking as we did, hit like, drop your opinion in the comments, and subscribe for more crazy courtroom breakdowns.
I have check stubs from Johnson. I'm just trying to do what I got to do. That's all. I'm not asking for no special favors, but I'm just asking for assistance and trying to get these matters taken care of so I can get my license back.
All right, Mr. Regier, the state's response to this argument?
Again, Your Honor, it would appear that the defendant has admitted on the record that he has no evidence, and by statute, the defendant is required to carry the burden of proof in this matter. Additionally, it is the state's position that pursuant to paragraphs 4 and 5 of the response, the defendant has failed to, or rather paragraphs 5 and 6 of the response, Your Honor, forgive me, that the defendant has failed to present any evidence, both by his own statements on the record and by the face of the motion, that any reinstatement fees have been assessed in this case specifically under KSA 82110 subsection C or F. And the language of the statute would appear to suggest, for purposes of subsection E2, procedure for post-conviction relief, and the state is not aware of any journal entries of conviction and sentencing in this matter. Alternatively, if the court finds that the defendant is entitled to seek relief under either of these subsections, the state's position is that the defendant has failed to meet his required burden of proof, both under evidentiary grounds and for the reasons stated in the response.
So how is it that this old case does not have a journal entry in it? 2002, and you're saying we don't have a journal entry?
Your Honor, the state is not aware of any journal entries of conviction or sentencing in this case.
Okay, but did he pay his ticket and was found guilty on at least the speeding? The insurance, he should have had to come to court.
One moment, Your Honor.
Okay, I'll look at that too from this end. I think there may have been a time when the district, whoever was doing the traffic at the time, may have allowed them just to go to the clerk and pay a fine and costs.
Your Honor, if the court is prepared to accept a proffer,
I will accept
from the public portal access case summary, this is a case that appears there have been no payments of any kind ever submitted.
What about that journal entry? No journal entry either?
Not from the state's understanding, Your Honor.
Okay, I'm going to ask the clerk, do you see anywhere in here a journal entry of conviction, or would you expect to if he just paid it at the clerk's office?
Your Honor, it may be down in the folder downstairs. It's an insurance charge. So it depends on how they filed the case back when they were doing the cases this way. If it was not listed as a must appear or a big file, I'm not sure if I would have the case.
And Your Honor, and there does appear to be a notation in the same public portal access criminal with a notation dating December 19th, 2002, that would appear to suggest a failure to appear.
Okay. So you didn't even appear to finish up your case, Mr. Collins, back in the 2002 era. And now that's probably why your financial balance is 586. That's probably what got you suspended, not paying these cases like you were supposed to. If you're coming in here asking me to waive your costs and fines, and you didn't even come to court and finish up your case, so I'm going to deny the request at this time. But we do need to get this case resolved. Are you going to have an attorney represent you on this speeding and no insurance charge, Mr. Collins?
Well, I guess so. I have insurance now, and so I guess not.
The question is whether you had it on 9/22 of 2002. Are you able to hire an attorney?
No.
Are you working at all?
Yes, I am, but I can't afford no attorney.
Where do you work?
At-
Oh, you've told me that. And they pay you how much per month?
I make per month after taxes.
Well, I think it's before taxes, but if you want to give me that, I'll take that.
Well, I average 1,200 every 2 weeks. I just
$2,400 a month. Well, I don't see you qualifying for a court-appointed attorney at that. You might. Are you married or single?
single.
Do you have any minor children you legally support?
Yes, I do. I have a 15-year-old that I have custody of.
Okay, any other children or dependents?
But I do pay child support for my older children. I'm still paying on that, yes.
Okay, how much do you pay per month for that?
$350.
$350?
It's in the paperwork. If you look at the motion and everything, all my financial obligations are listed.
Okay, and what do you pay on your utilities?
I pay $202 a month for electric, $150 for gas, $150 for water. I have a ongoing bankruptcy case that I paid $340 a month for that. Transportation for gas and food and everything, that's about 300. Yeah, so everything comes up to be about average a month, 25.62.
All right, well, even though
Which
you're
you
getting
actually
paid
receive
good
more than
money,
what I make.
yeah. All right, I'll go ahead and appoint Attorney Darren Patterson if you want an attorney. Do you want one?
Sure.
And I'm going to set this over to a Monday at 9 a.m. Missy, or I'm sorry, Destiny, when do you want that?
Your Honor, I have December 15th.
We'll all be back here December 15th. I wonder if we ought to put that on a 1:30. Do we have any 1:30s around that time?
That would be a Monday, Your Honor. Would you like to set it for a bench trial on a Wednesday instead?
Well, I'm just thinking, I want to make it convenient to Mr. Patterson on a Monday, but at the same time, this could take a while, so I don't want to take a long docket. And let's try for a Wednesday afternoon at 1:30, non-interpreter docket, not one of those.
Of course, Your Honor. I have November 19th at 1:30.
Mr. Regier, will that be sufficient for the state?
No objection, Your Honor. And the state will be requesting really as to if that is for control purposes or some other purpose.
Let's make that for.
As the court has deemed it appropriate to appoint the public defender to this matter.
All right, we'll set it for control. And Mr. Collins, you'll need to be back here November 19th at 1:30. But today you need to call your attorney,
Is that
Darren
November 19th or December 19th?
Well, which is it, Destiny?
It's November, Your Honor. 11/19/2025 at 1:30.
I'm trying to get my damn license back. I have my license back on the 18th, and they got to go through all of this mess, man. That's crazy.
All right. Well, you talk to Mr. Patterson. He's very competent in these areas and can give you some good advice and help you present your case well. So his phone number, or do you want his phone number?
Yes.
You ready for it?
Yes.
316-322-7.
Thank you.
You're welcome. If there's nothing further, Mr. Collins.
Your Honor, there is one final matter.
Yes.
Your Honor, count 2 of this case does appear to be charged as a Class B misdemeanor, and the state is not aware of any appearance bonds in this case either.
All right, because you have a B misdemeanor, I am required to order that you go into a breakout room. It's going to come up on your screen here in a minute, invitation to breakout room or something like that. Click on that and you'll go into a breakout room with court security 2. He's going to set up with you a time for you to get out to the Butler County Jail and get your picture and prints taken. I won't make you put up a cash bond, but I will make you put up 1,000 OR. You won't have to put that money up unless you fail to come to court or comply with bond conditions as ordered by the court. But you will need to set up a time and get out there and get that done by your next court date.
Yes, ma'am.
Anything else now, Mr. Regier?
Not from the state, Your Honor.
Anything further, Mr. Collins?
No. This is
All right.
ridiculous. Trying to do right and get saved.
Well, watch what you're saying, Mr. Collins. You don't want to get into other problems. All right. Please, Destiny or whoever's running the hearing, you could put them in the breakout room.
Mr.
Brocky Collins, are you here? Or did you cancel him, Mr. Patterson, as he was your client?
I don't remember or know if Jasmine canceled him, but I did have Brock Collins and I show as dismissed. Also I had Jamie Williams, but it was also then previously dismissed.
Court Security 3?
Yes, I do have Brock Collins here.
All right, well, bring in Brock Collins first. All right. And Deputy and Court Security 3, is that Mr. Collins with you?
Yes, Your Honor.
All right. We will be on the record now in 2002 TR 3024, State of Kansas versus Brock E. Collins. Jared Regier for the state, Darren Patterson for the defendant Brock Collins, who also appears in person. And Mr. Regier, I understand the state dismissed this motion for hearing.
Your Honor, the state's information is that on November 18th of this year, approximately 1 day prior, or rather less than 1 day prior, a journal entry of dismissal without prejudice was filed by my office.
All right. That matter being dismissed, Mr. Collins is excused from these proceedings. Does he need to report to anyone again, or is he through?
Judge, that was a case that had not went to disposition, so it is basically finished.
All right. Mr. Collins, you're excused. You may go at this time. Your case is closed.
And Your Honor, that is without prejudice per the previous journal entry.
That'd be fine. Yes.
Thank you, Your Honor.